Ladies and gentlemen, this is Signet TV, the nationalist show. I'm your host and analyst, Kennedy Abongo. Today, we are going to talk about Karua's intention to go to the EACJ, that is East African Court of Justice. That indication was given yesterday. We are going to analyze it, whether it is a good thing to do, and also the challenges that it presents. Before we do that, ladies and gentlemen, do kindly subscribe if you're watching us for the first time. And if you've been watching us, also we urge you to subscribe. We want this show to grow so that we can reach, to so many people out there with these messages. Provide you with the most objective analysis of issues. Now to the topic under review today, Karua to go to East African Court of Justice. So what is my take on it? My view, I'm rather disappointed, I must say, that there is still leaders from the Azimio side who still keep this hope and would want our people to still have this hope that something may yet happen, which may, in some way or another, remove or, ensure that the judgment by the Supreme Court, which held the win by Dr. Ruto as the president-elect of this country, overturned. Let me say this assertively before I proceed, that will not happen. And in fact, Karua's intention to go to EACJ is as well ill-advised. Let us look at the jurisdiction of that court. What can that court deal with? For those who are not aware with or apprised of the legal terms, jurisdiction means the capacity of that court to hear certain things. When a court is established, normally the law provides what it can and cannot hear, or what it can and cannot entertain. So that is what we call jurisdiction. So when maybe you're charged or accused of having murdered someone, then the jurisdiction or the court with the capacity to hear your case is always the High Court. So you cannot be taken to these other courts. It is always the High Court with that jurisdiction. So courts have the capacities that are set by law. So in some instances, you'd find probably the High Court, because of backlog, may decide to give some of those duties to lower courts, probably the Chief Magistracy. But why is Karua going to the EACJ? With respect to a matter that touches on a presidential petition, we do have a constitution. Our constitution provides that such matters are to be heard by the Supreme Court when it is a presidential decision. And the decision of the Supreme Court cannot be challenged anywhere. And in fact, you cannot even go to any other court to seek clarification based regarding the decision of that court. So there are some people who say that the intention of Karua is just to seek clarification of that judgment. First and foremost, I must say, and I believe I've stated this, that the court, in giving its judgment, may have used much stronger words. Words like hot air, words like, wild goose chase. All those words were quite unnecessary for a court sitting and hearing a presidential petition. I'm saying so because it was intended to somewhat, ensure that people do not approach the court in future to file such kind of petition, when in fact the court was established specifically for that purpose. So when you use these words which are so strong and admonishing, it is not good for litigants in future to come to court, again to approach court with such matters. But that notwithstanding, going to EACJ will not in any way help matters. In fact, it does worse, because there are some people who are now glued and hopeful that something may come out of it. But the court does not even have jurisdiction. That is what I'm wondering why Ms. Karua, who is a senior lawyer, advocate, would do that. So what does the court have jurisdiction to hear? One, dispute on interpreting the application of the treaty. That is the treaty that is forming or establishing that court itself. Number two, dispute between the community and its employees arising from terms and conditions of employment or interpretation and application of staff rules and regulations. That's the second one. Those are the disputes it can hear. Number three, disputes between partner states regarding the treaty if the dispute is submitted to it under the special agreement. Again, in that instance, a dispute between maybe Kenya and Uganda, but it has to be submitted to the court under a special agreement. Another thing is dispute arising out of arbitration clause contained in a contract. So people enter into some sort of contract and say that in case of a dispute, let us refer this to EACJ for determination. So that way the court can assume jurisdiction over such contracts. Number 5, I believe, dispute arising out of arbitration clause contained in commercial contracts. This is again tied to the fourth one. And then the last one, the jurisdiction of the court may be extended to human rights at suitable date to be determined by the council. So they may be extended. If you look at the wording, the jurisdiction of the court may be extended, meaning it is not quite a must. But in certain instances, it may be extended, and hearing such disputes again would be determined by the council at what proper date such dispute should be heard. So Ms. Karua, if you remember, had gone to that court when she's after the High Court, I think, upheld Waiguru's win against her. She went to that court, but she did not go to that court to seek redress arising from that election petition. She went there and coined her, claim based on human right violation, not because of election petition. So I wonder how she is going to that court, as some people are saying, to challenge or seek clarification on the judgment of the court. That is not the jurisdiction of that court, and that court cannot entertain that kind of application. And if it does, then that would be an affront to the sovereignty of the people of Kenya, who had decided to give the power to determine presidential petition and anything that pertains to it to the Supreme Court. Ladies and gentlemen, I don't want to use this word, but again, that is a wild goose chase. Thank you very much.